Final details for the nature and effects of obligations are set in Articles 1174 to 1178. Excerpts are taken from the Law on Obligations and Contracts by De Leon. Welcome to the course. Article 1174 discusses fortuitous events. It states, except in cases expressly specified by the law, or when it is otherwise declared by stipulation, or when the nature of the obligation requires the assumption of risk, no person shall be responsible for those events which could not be foreseen, or which, though foreseen, were inevitable. What do we mean by fortuitous event? A fortuitous event is any event which cannot be foreseen or which, though foreseen, is inevitable. Stated otherwise, it is an event which is either impossible to foresee or impossible to avoid. The essence of a fortuitous event consists of being a happening independent of the will of the debtor, and which happening makes the normal fulfillment of the obligation impossible. In speaking of the contract of lease, our civil code distinguishes between two kinds of fortuitous events, namely, ordinary fortuitous events, or those events which are common and which the contracting parties could reasonably foresee, just like rain. Second, extraordinary fortuitous events, or those events which are uncommon and which our contracting parties could not have reasonably foreseen, such as earthquakes, fire, war, pestilence, pandemic, or unusual flood. There are requisites of using fortuitous events to avoid damages. They are the following. First, the event must be independent of the human will, or at least the debtor's will. Second, the event could not be foreseen, or if foreseen, it is inevitable. Third, the event must be of such a character as to render it impossible for the debtor to comply with his obligation in a normal manner. And lastly, the debtor must be free from any participation in or the aggravation of the injury to the creditor, that is, there is no concurrent negligence on his part. Article 1175 states that usurious transactions shall be governed by special laws. When talking about simple loan or mutuum, it is a contract whereby one of the parties delivers to another money or other consumable thing upon the condition that the same amount of the same kind and quality shall be paid. It may be gratuitous or with a stipulation to pay interest. On the contrary, usury is contracting for or receiving interest in excess of the money allowed by law for the loan or use of money, goods, chattels, or credits. In order that interest may be recovered, the following requisites must be present. First, the payment of interest must be expressly stipulated. Second, the agreement must be in writing. And third, the interest must be lawful. A stipulation for the payment of usurious interest is void, that is, as if there is no stipulation as to interest. Article 1176 states, the receipt of the principal by the creditor, without reservation with respect to the interest, shall give rise to the presumption that said interest has been paid. The receipt of a later installment of a debt, without reservation as to prior installments, shall likewise raise the presumption that such installments have been paid. By presumption is meant the inference of a fact not actually known arising from its usual connection with another which is known or proven. Assumption, on the contrary, is coming up with a conclusion without any reason or evidence, like how values are assumed in certain variables when designing a construction member. There are two kinds of presumption. They are conclusive presumption, which is one which cannot be contradicted, like the presumption that everyone is conclusively presumed to know the law. Second, disputable or rebuttable presumption, one which can be contradicted or rebutted by presenting proof to the contrary. Article 1177 states, the creditors, after having pursued the property in possession of the debtor to satisfy their claims, may exercise all the rights and bring all the actions of the latter for the same purpose. Save those which are inherent in his person, they may also impugn the acts which the debtor may have done to defraud them. In case the debtor does not comply with his obligation, the creditor may avail himself of the following remedies to satisfy his claim. First, exact fulfillment or specific performance with a right to damages. For example, a person who loaned another the amount of 1 million would also claim the full amount of money back. Second, the creditor can pursue the leviable property of the debtor. Leviable properties are those which can be seized upon a writ of execution issued by the court to pay a money judgment granted in a lawsuit. In the same scenario, if the debtor can only pay 600,000 of his loan, the creditor can pursue the sale of the debtor's car to compensate for the loan. Another option is, after having pursued the property in possession of the debtor, the creditor can exercise all the rights like the right to redeem. In the same example, the creditor can take the car of the debtor. Thirdly, the creditor can bring all the actions of the debtor like the right to collect from the debtor of his debtor. In the same example, if the debtor also loaned another individual a certain amount, the creditor may ask the court to order the individual not to pay the debtor so that the payment may be made to him. Lastly, the creditor can ask the court to rescind or impugn acts or contracts which the debtor may have done to defraud him when he cannot in any other manner recover his claim. He may ask the court to rescind or cancel the sale made by the debtor to another individual on the ground that the transaction is fraudulent in case he cannot recover in any other manner his credit. Article 1178 states, subject to the laws, all rights acquired in virtue of an obligation are transmissible, if there has been no stipulation to the contrary. The article discusses transmissibility of rights or obligations. The rights of the creditor can be passed to his heirs, so the obligation is not actually extinguished after his death. The heirs have the right to collect the obligation from the debtor. The exceptions of the article are as follows. First, prohibited by law. When prohibited by law, like the rights in partnership, agency, and comodatum, which are purely personal in character. Second, prohibited by stipulation of the parties. When prohibited by stipulation of the parties, like the stipulation that upon the death of the creditor, the obligation shall be extinguished, or that the creditor cannot assign his credit to another.